Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian Lerner. We have a little bit different of a location that I'm doing Coffee Talk today. I'm actually doing it on a cruise. So if you hear some strange background noise, um, well, we're on the Lido deck, and it's probably playing some kind of Caribbean music. But at any rate, I wanted to do a video on why sometimes, even though you have a qualifying relative that can petition you, it won't help. Okay, and there needs to be other options that are looked at. I have some cases where they walk in thinking all they have to do is have their 21-year-old U.S. citizen son or daughter petition them, and boom, they're going to get their green card. And sometimes it doesn't work like that. So let me give you an example so you understand the situation, and then I can explain in more detail why, so it's more clear. So for example, let's say that somebody came here illegally from whatever country 15 years ago, and let's say that they're a single parent. And then let's say that they had a kid that was born here, and now that kid is about to turn 21. And all they've heard is that when your child, who's a U.S. citizen, can petition you when they become 21, and then you're going to get the green card. So they come into my office, and I ask some questions. I find out that, yes, the son's going to be about 21, and that, yes, eligibility-wise, a petition can go forward. But the key here is, how's this person going to get the green card? There's no problem with an I-130 petition from, in this particular example I'm giving, from a son who's 21 petitioning his mom. There's no problem with that. But the I-130 approval does not mean that you have the green card. It doesn't mean you can get the green card. It doesn't mean you're eligible for the green card. All it means is that you have a petition from an immediate relative who that person claims to be as a U.S. citizen, and you're who you claim to be, and the relationship exists, and thus the I-130 would be approved. However, once the I-130 is approved, then you have to decide whether or not you're going to be eligible to adjust status in the U.S. to get the green card, or whether you have to consulate process outside. So in many cases, if the person is not eligible to adjust in the U.S., which in this particular case I gave you, the person's not. The person would have come into the United States illegally, and had no prior petitions filed on their behalf, so they don't qualify for what's called 245I. So the person doesn't qualify to adjust. So then the only option is consulate processing, where eventually they have to go outside and consular process. So then I get the same questions as well. Going, okay, well, I'll just do a waiver. I'll do a waiver. Hopefully it'll be approved, and then I'll go get my green card. Well, in order to do a waiver, you have to have what's called a qualifying relative. Okay? The key and what qualifying relative means is that some relative of yours meets the statutory definition of a relationship that is eligible in which to be able to show suffering to that person and to be able to apply for the waiver. So many times, for example, as in this case, the person comes in, they came here illegally, let's say they have no crimes, no deportation orders, nothing like that, but they don't qualify to adjust, so they have to leave the country, and in the moment they would leave the country, they're subject to the 3 to 10 year bar, and in most cases the 10-year bar. So people don't want to stay out for 10 years, right? They want to come right back. So there is what's called a waiver of the 10-year bar, and that is a whole package that's put together that essentially shows the hardship to the qualifying relative. Now, what is a qualifying relative for a waiver of the 3 to 10 year bar? Well, what that would be is a spouse or a parent who's a lawful permanent resident or U.S. citizen. It is not a son or a daughter, which means, as in many cases where there is a single parent And even if they're married, it's still not going to make any difference if the other parent is not a resident or a citizen. But in this case, if the son wants to petition the mother, that's fine. But then the mother doesn't qualify for a waiver because she has no qualifying relative. She only has a son who is a U.S. citizen, not a spouse and not a parent. Now, again, even if she was married, for the last 42 years and her spouse is here illegally, she still doesn't have a qualifying relative, which would be a spouse who is a lawful permanent resident or U.S. citizen. So, without the qualifying relative, there is no eligibility to do the waiver, period. Okay, it can't be done. And because of that, sometimes these people think that just because they have a relative that can petition them for an I-130, that automatically they will qualify for the waiver, and it doesn't work like that. And that's why I start going off on other areas they may qualify. Let's see, perhaps cancellation of removal if they were put into removal proceedings, possibly asylum, convention against torture, withholding of removal, possibly registry, possibly VAWA or self-petitioning, possibly a U visa, possibly an S visa or a T visa. All of these different options eventually can lead to the green card. And number one, they either don't need a waiver, or the waiver they need, it has a different relationship that can qualify for a qualifying relative. So hopefully this has made some sense, and hopefully it is clear why in some cases, even though you might qualify for the I-130, you don't qualify for a waiver. But many times there's ways around this. There's other paths that can be taken. So that's generally why I ask all the questions I do in a consultation, to find that path. Okay, if you like the video, click like, subscribe, and then more on the coming weeks. Thank you.